commenced as the Director-General of Security on Monday of last week. He comes to the position with an extremely illustrious record of service to the Australian people as a former Commander of Special Forces, as a former Secretary of the Department of Defence, as a former National Security Advisor to two Prime Ministers, Prime Minister Rudd and Prime Minister Gillard, and as most recently as the Australian Ambassador to NATO and the European Union. I'm delighted that Duncan Lewis accepted the appointment which the Prime Minister and I announced earlier in the year. He has come, of course, it goes without saying, at a particularly important time. I'll just mention words of his own, and then words of his own, and then we'll have some of his own, and then we'll have some questions. As you know, there are two packages of legislation in relation to national security that will come before the Parliament this week. The first package of legislation, what has sometimes been called Tranche 1, deals with the powers of the national security agencies, and it is based largely upon the cross-party recommendations of the Parliament's Intelligence Committee during the course of the last Parliament. I introduced it into the Senate in the first week of July. It's been back to that committee for consideration. That committee has made 17 recommendations, some of which involved small changes to the legislation, in particular to enhance the oversight mechanisms within the legislation. And last Friday I announced that the government is accepting all 17 of those recommendations. The second package of legislation, what is has been called the foreign fighters legislation, has been prepared to deal specifically with the menace to Australia and threat to Australia's security posed by those who travel to the theatres in the theatres of war in Syria and northern Iraq in particular, and return to Australia's shores potentially with malevolent intent. It was the view of the government that the current suite of laws was not sufficient to deal in all circumstances with the threat imposed by people of that kind, and therefore I was asked by the National Security Committee to prepare legislation to that effect, and I've done so. I've briefed the opposition about it. I will be taking that legislation through the government party room tomorrow. In the event that it is endorsed, as I expect it to be, I will be providing a copy of the text to the Shadow Attorney-General. As I said, I've already briefed him extensively about it, and I will be providing copies of releasing copies of the bill to members of the media tomorrow afternoon ahead of its introduction into the Senate on Wednesday. At that point, I would expect that the bill will be referred to the Parliamentary Intelligence Committee, and I'll be asking the Parliamentary Intelligence Committee to report so that the legislation can be dealt with in the sitting fortnight after this. You're also aware that in the past several weeks, both the Prime Minister and the Parliamentary Secretary for Multicultural Affairs, Senator Concetta Fierravanti-Wells, and I have engaged in very extensive community consultation. Among that community consultation, there has been a number of meetings with senior leaders of the Muslim community in Australia. The purpose of those meetings was to advise them of the government's intentions, to engage them so that, as I have said to them many times, so that they may act as partners with the government in seeking to protect youngsters in their communities, young men and indeed young women, from being enticed by into the snares of ISIL and other terrorist organisations engaged in warfighting in the Middle East, and to seek their feedback about the legislation that the government had in development. Now, this was a greater level of community consultation than is usual. Points they made to me, and when I say to me, I was accompanied at those meetings not only by Senator Concetta Fierravanti-Wells, but also by senior officers of the Attorney-General's Department, of ASIO and of the Australian Federal Police. One issue that came up time and time again was the question of sunsetting important provisions of the legislation. As you will recall, when the devices of preventative detention orders and control orders were introduced into the Commonwealth Criminal Code in 2005, they were subject to a sunsetting provision. They sunset, in fact, in December of 2015. The government was of a mind to remove those sunsetting provisions in relation to preventative detention orders and control orders. But we have heeded the very, very strong view of leaders of the Islamic community that removing the sunsetting provisions would send a bad message to that community. So what we've decided to do is to renew the relevant provisions at the time they would ordinarily sunset in December of next year, to roll them forward, as it were, but to retain a sunsetting regime so that those provisions will sunset in 2025. That's a long time into the future. It'll be a matter, I dare say, for future governments to consider, but we want to reassure those of us who have raised this issue with us and been at pains to point out what an important issue this was for them, that we have listened to them, we have heeded what they've had to say, and we have made a decision to retain the mechanism of sunsetting those provisions. In Tranche 2, that is the foreign fighters legislation, we will be introducing a new offence, and that is the offence of travelling to a zone or a locality, I should say, declared by the Minister for Foreign Affairs to be a declared locality. This is unusual in our law. The point was put to us very strongly by leaders of the Islamic community that for a new and unusual provision like this, there should be a sunsetting regime as well. And the government has agreed to amend, well, the legislation hasn't in fact been introduced, but the government has agreed to accommodate that view, and so I'm announcing this morning that the declared areas provision in the foreign fighters legislation will be also subject to a 10-year sunsetting provision, and that can be considered by a future government in a decade's time. We have done this because we understood the points that were made to us by members of that community. It doesn't weaken the legislation in any respect whatsoever. It merely adds yet another element to the review mechanisms that are already in place. And as you know, at an earlier time I announced a decision to retain the Independent National Security Legislation Monitor, and there are all the other executive and parliamentary review mechanisms in place as well, so that these provisions that are unusual in our law will be the subject of a multiplicity of review and oversight mechanisms. Lastly, can I just touch on an issue that has arisen in the last couple of days, and it involves the provisions in the first tranche of legislation, the agency powers legislation, to deal with special intelligence operations. These provisions are largely modelled on the existing provisions of the Commonwealth Criminal Code, which deal with the Australian Federal Police and enable them to undertake protected operations. You can readily imagine that when ASIO officers are engaged, particularly in covert activities, when, for example, they penetrate terrorist networks, there are very good and sound legal reasons why they should be protected from legal liability. Let me give you an example. If there were to be, for instance, a covert ASIO officer who had penetrated a particular network, it would be necessary for that person, for the operation to be effective, to, as it were, play along with the planning of that network. It is important that there be a protection from legal liability. But it's also important that that protection be only so far as is necessary and proportionate. At the moment, in the draft legislation, a covert or a special intelligence operation could not be authorised if it caused the death or serious injury to a person, involved the commission of a sexual offence, or resulted in significant loss or serious damage to property. It's been said by some that that would allow ASIO officers to be engaged in the practice of torture. Now, that assertion, that claim, is not right, because ASIO has no power to engage in that practice. Torture is against Australian law. No operation which authorised torture could ever be validly authorised under the powers that ASIO has. Nevertheless, I don't want the discussion of this important issue to be diverted by an issue that is effectively a red herring. So this morning, in consultation with the Director-General and in consultation with the Prime Minister, I've decided to add an explicit prohibition in relation to torture in so far as concerns special intelligence operations. Now, I want to stress that there is absolutely no necessary legal reason to do this. I am doing so because it is something that ASIO is perfectly happy to have expressed on the face of the legislation, and so as to avoid this debate being diverted by an issue that is nothing but a red herring. But that will be in the legislation when I introduce it on Wednesday.